Okay, good morning, good afternoon, and good evening, everyone. My name is Kun Fan. I'm a member of the Herbert Smith Freehill China International Business and Economic Law Center. I'm very delighted to welcome you all to the first panel of the second annual conference, hosted jointly by the Tsinghua UNSW Joint Research Center for International Commercial and Economic Law. So this JCICEL was established in 2019 between the UNSW Law and Tsinghua University Law School. And the aim was to develop a group of world-leading researchers in the field of international commercial and economic law on general legal issues and also China-specific issues. So we're very happy to welcome you all to our joint conference. And I will begin today by acknowledging the traditional custodian of the lands on which we all meet today, the Bedigo and Gardigo people for where UNSW stands, and also pay my respect to the elders past, present, and emerging. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who are present here with us today. And before we start, I would like to thank also Herbert Smith Freehill for their continued support to the CBEL, and also Tsinghua Law School colleagues for participating in the conference. We're very pleased today to have a panel of distinguished speakers to join our discussions on various topics. So I will introduce each panelist just right before they speak. And our format is for our panelists each speak between 12 and 15 minutes, and then we will open up for questions. So if you have any question, you can also list it, put it under the Q&A function. We will try to address as many as we could in the end. So there's a slight change in the order of presentation. Our first speaker today is Professor Weihuan Zhou, who is an associate professor and director of research at the Faculty of Law and Justice, and he is a member of CBEL as well. Professor Zhou published in the field of international economic law, particularly the nexus between international trade law and China. His work has appeared in a lot of top journals in the field and in some of the best journals in the broader field of international law. And his publications are widely cited, including the European Parliament briefs and reports of the Parliament of Australia and Australia's Productivity Commission. Currently, he is also co-secretary of the Society of International Economic Law. And prior to UNSW Law, he was also a trade and commercial lawyer and a legal consultant at the WTO. So he has also a lot of experience in research about state-owned enterprises. And Weihuan's topic today is joining the Cptpp and reforms of the state-owned enterprises. So without further ado, I would like to give the floor to our first speaker, Professor Weihuan Zhou. Weihuan, the floor is yours.
Thanks, Quinn, for the introduction. Can you guys hear me fine?
Yes.
Good. Today's topic is really tries to touch upon one of the perhaps the most heated debated topics of today, since China's request for joining the Cptpp, I think 2 months ago by now. The objective is not to really dig into the procedural issues and all of the substantive issues in relation to China's requests or possibly accession to the Cptpp. The objective is to bring us back to the more fundamental issue, to provide a critical analysis of the rules of Cptpp on state-owned enterprises, and for us to rethink about the implications for China's entry into the Cptpp if we actually get to that stage, and China's own reform of state-owned enterprises, and more generally, the future regulation at the national level. Next slide, please. So I will start with a brief review of the concerns of China's major trading partners. So, but obviously the United States would be the major complainants, if you like, in relation to China's economic model. and more specifically, the specific position of several existing members or parties in the Cptpp regarding China's request for joining the Cptpp. I will then very briefly consider China's current round of reform of state-owned enterprises beginning from 2013, and just set a background for a more detailed discussion of the Cptpp rules and existing China's obligations under the WTO. The first two parts, as I said, provides necessary background and context for discussion. And the third and the fourth parts of today's presentation, we'll talk about, again, very briefly, given the time I have, Cptpp's 5 major sections on regulation of state-owned enterprises, their effectiveness or potentially lack of effectiveness at regulating China's SOEs, particularly in the context of China's current SOE reform. I will also explain why China's existing obligations under the WTO tend to be more rigorous and effective. The final section, obviously, I'll try to raise some questions for us all to think about, and I'm happy to follow up on these questions in the Q&A session. Next slide, please. So some background and kind of review of the statements by China's major trading partners, and obviously the US is the starting point and is the major point. And the US-China trade tensions in the past 3 years, I think by now, are well known. One of the most fundamental concerns of the US has been on China's state-led economic model. As you can see, I mean, this is on the left-hand side of the slides is the US 2019 report on China's WTO compliance, and that's under the Trump administration. And on the right-hand side is a recent speech by USGR Catherine Tai, and she has actually made several speeches already, but this is one of the examples. The key message there is to show that the US was concerned under Trump administration on China's state-led economic model, and that was the key concern. And that concern has remained and continued under the Biden administration. So these fundamental concerns, despite the change of administration, have not been changed. And if you read the USGR Catherine Tai's speech in its full version, you will see that the approach of the US seems to remain the same as well, being that the US will be resorting to all possible approaches and tools to deal with China's state-led economic model, which says the importance of China's state-owned enterprises and the role that state-owned enterprises plays in this context. Now, the US concern is largely shared by the other major players in the system, in the global trading system, particularly the European Union and Japan. And if you read a series of joint statements made by the 3 parties in the past 2 years or 3 years even, you will see that the key concern, again, involves China's state-led economic model, the role of state-owned enterprises, and the impact on China's trading partners. So, and that's why it is important to think about the international rules on SOEs and China's SOE reforms now and towards into the future, and especially given the context that China is now requesting to join the Cptpp. Next slide, please. So I just want to provide a collection of statements by the major existing parties in the Cptpp that have actually spoken on China's request. On the left-hand side, the statement by Japan and Australia tend to be a little bit more negative than statements by New Zealand and Malaysia. We tend to be more neutral and positive about China's entry. I don't want to make too much to give too many comments on these statements, because I think you need to kind of read these statements in the context, as well as you need to read these statements in the full version. But a general concern by some of the major parties, particularly as illustrated by Japan's and Australia's statements, is that first, whether China will be able to comply with the high standards set out in the Cptpp. That includes the SOE rules being one of the major issues. Interestingly, the US is well known not a Cptpp member. Even the Cptpp, its predecessor, the TPP, was led by the US. Most of the rules in the TPP were incorporated into the Cptpp. So the US was really a major designer of the rules. But US withdrew under the Trump administration from the Cptpp. So US statement was interestingly neutral and left it to the other parties, the existing parties in the Cptpp, to decide. But we should not underestimate the impact of the US on China's entry process, at least at the background. All right, next slide, please. So, I mean, given today's audience, I would not speak too much about China's SOE reforms. But I just provide some information about the different major elements of the current reform, and for us to reflect on. I perhaps just provide some questions for us to think about. I mean, these questions reflect some of the general concerns in a global society about China's SOE reforms, and in the context of international trade regulation, about how these reform and SOE activities in China would be compatible with international rules on SOEs. That includes WTO rules and the Cptpp rules. So some of the concerns and outstanding issues include, for example, whether the reform has led to a resurrection of the state sector and increasing use of SOEs for industry policies. And second, for example, the classification of SOEs remains unclear, and all types of SOEs remain under the state control, and hence not purely commercial entities. And third, whether the corporate governance reform and the mixed ownership reform have led to some more influence of the state on not only SOEs, but also private entities, again, in the pursuit of industry policies. And finally, whether the reform has led to more market distortion and unfair trade practices, which have been the concern of China's major trade partners, as I just noted. So, I mean, again, these are not my views, but I'm just trying to reflect on the concerns of China's trading partners in the context of China's current SOE reform. And these provides a context not only for China's compliance with the WTO rules, but also for China's entry into the Cptpp. Next slide, please. So this is the major part of this presentation, which is trying to compare the rules under WTO and the Cptpp in relation to SOEs. Broadly, you can think about this as the impact of the states in the market on the market that has spillover effects impacting on China's trading partners. So the WTO has a range of rules that are trying to deal with this, the states sector, and also about the activities of SOEs on markets. I would not have time to go through everything, but some of the major issues about the current WTO rules that have been consistently discussed in the scholarship and also by policymakers, including some of the weaknesses or limitations, for example, the coverage of state entities, the scope of the substantive obligations, lack of transparency, and the ineffectiveness of the notification mechanism, the scope of the anti-dumping agreement for the use of anti-dumping to deal with state-led market distortions, and the issue of public body, or whether SOEs can be treated as a public body, which is a precondition for the use of countervailing measures. Now, these are general WTO rules, and some of these are actually elaborated and made more rigorous under China's WTO Plus obligations, which I will come back to talk a little bit more later on. Next slide, please. So these general rules provide the basis for the discussion of the Cpttp's SOE rules. In terms of whether the Cptpp SOE rules have advanced the existing rules under WTO, and whether the Cptpp SOE rules would be more effective in regulating Chinese SOEs. Okay, and again, I would not have time to go through everything, but I'm just setting out the 5 major elements under the Cptpp SOE chapter, which is chapter 17 of the Cptpp. And it includes the definition obligations, transparency, and the subsidies, and also about exceptions. Now, the way to think about the Cptpp SOE rules, the starting point, I think it's a threshold question as well, is about the scope of SOEs, so the coverage, whether it is broader than the WTO definition or WTO coverage of state entities. And you can see that there are some kind of conditions in relation to the coverage of SOEs, and how this definition could cover all Chinese SOEs, given the current classification of SOEs under China's current SOE reform, and whether this definition covers effective control, even if you don't have a majority interest in the company. And obligations, if you look at Article 17 of the GATT, which is the general WTO rules on state trading entities, you will see that the Cpttpp's substantive obligation have extended it to cover commercial considerations, requiring all state entities to undertake purchase and sales solely based on commercial considerations. But that, as I will explain later on, that does not extend beyond China's current obligations under China's WTO accession instruments. So those rules only apply to China. Next slide, please. Again, subsidies is based, so the Cpttpp's SOE rules cover subsidies, or also called the commercial assistance. The importance in this definition and the scope of coverage of the rules on subsidies is that it's based on WTO subsidy agreements. So the question is, to what extent it extends beyond the WTO subsidy agreements. The only thing you could argue is that it extends to the services sector, whereas the WTO subsidy rules currently only covers trading goods. In relation to transparency, which is perhaps the most advanced development in the Cptpp SOE chapter, which sets out detailed requirements and obligations on transparency and notification, including providing detailed information on SOEs and subsidies. But again, the question is how you enforce it, right? The enforcement is the big problem and the major problem under WTO's transparency obligations, and it may well remain the same significant issue under the Cptpp. And finally, exceptions and non-conforming measures. So you include general exceptions and country-specific non-conforming measures. So if you look at some of these general exceptions, includes Vietnam, Malaysia, and Mexico. The countries have the largest state sectors among Cptpp members, are exempted from the transparency requirements entirely for their subcentral SOEs. So local SOEs notification requirements are largely exempted. Mexico, Vietnam have the most extensive non-conforming measures as well. And these examples suggest that China may also negotiate similar non-conforming measures so as to maintain the strategic role of SOEs for economic development and for its own industry goals. So now this is just a very, very brief overview of the Cptpp rules. It's actually quite detailed. Now, how these rules compared with China's WTO plus obligations. Next slide, please. Very briefly, China's WTO plus obligations are broader and more rigorous. It includes all SOEs and state-invested enterprises. Okay, and there is no definition, but there is no restriction on the definition. So you can make an argument that it's not subject to, for example, the majority interest requirements as required under the Cptpp SOE chapter. It has the same substantive obligations, being non-discrimination and making decisions on commercial considerations. Importantly, there is no exceptions. Now, if you're familiar with the WTO laws, in two of the WTO cases against China's export taxes, the patent body basically said that it needs textual basis for a country to invoke general exceptions, and there is none such textual support for China to invoke the general exceptions under the GATT. So, which means that, in contrast with the Cptpp's wide range of exceptions, the China's WTO plus obligation provides no exceptions. Next, please. And yet, China's WTO plus obligation has even broader provision, which is Article 9.1 of the accession protocol, which is basically requires China to allow prices for all traded goods and services in every sector to be determined by market forces. Okay, it provides lots of flexibility for you to interpret in a very broad manner. So if combining with the previous provision, it basically requires the government not to intervene in the market and not to use SOEs to intervene in the market. And again, there is no exception to it. Next slide, please. I don't want to talk too much about these slides, but this is more specifically about the use of countervailing measures. So if it provides a subsidy, and these China-specific rules under WTO provides the flexibility for investigating authorities to find that there is subsidy and provided by a public body, and that causes injury, right? So these are the most important ways or issues in a countervailing investigation that faced by investigating authorities, and the WTO rules have been criticized for being too strict, so imposing higher condition and requirements on investigating authorities. And obviously, this special rule on China relaxed these conditions and restrictions and facilitates an investigation into Chinese subsidies. Next slide, please. So, as I said, I can only talk very briefly. Now, these are the questions I want to leave for the audience to think about. So I'm happy to take these questions in the Q&A. China should be thinking about the entry into the Cptpp in relation to its current SOE reforms, and broadly how China should respond to other reform of the WTO rules. And if China agreed to join the negotiation to update the WTO rules, would the Cptpp SOE chapter provide a model? I will just stop there. The final slides provide some kind of resources you can have a look on this topic. Thanks for your attention. Thanks.
Thank you, Wei Huang, for the great presentation and insights, and also the question you raised really pushes us to think a bit further on the future of SOE reform. So we might have time to come back to it during the Q&As. And now we will move on to our next speaker, Dr. Lu Wang. Dr. Lu Wang is a lecturer at UNSW Law and Justice, and she is also a member of CBEL. And her primary areas of research interest is international comparative economic law, with a particular focus on international investment law, international arbitration, and also state-owned enterprises and Chinese regulation of foreign trade and investment. She has published on cutting-edge issues in international economic law with leading international academic publishers, and also served as co-guest editor to the Exit Review, special focus issues on SOEs and international investment law. Before joining UNSW Law and Justice, Lu worked as a legal intern at the Exit and also the Department of Treaty and Law of MOFCOM. She was also a visiting fellow of the Letterpack Center for International Law at the University of Cambridge, and currently Lu serves as an affiliate expert of the Asian Pacific FDI Network and works closely with international organizations and key actors involved in the field of FDI. She holds 2 PhDs from the University of Liverpool in the UK and Xi'an Jiaotong University of China. So Lu will also be talking about state-owned enterprises, but from a different perspective. Her topic today is regulating state-owned enterprises through international investment agreements, a critical analysis of the EU-China CAI. So Lu, the floor is yours.
Thank you very much, Kun, for your kind introduction. Hello, everyone. Great to see you all online today. It's my pleasure to participate in the annual conference of Tsinghua UNSW Joint Research Center again and be part of this stimulating panel discussing some recent developments in SOE rules and competition law. My presentation is also about regulating the behavior of state-owned enterprises, but I will draw your attention to another significant international legal instrument, the Comprehensive Agreement on Investment between the EU and China, which contains detailed rules for state-owned enterprises and may prove crucial for the future of international SOE disciplines and global investment regime. Next slide, please. My presentation includes 3 parts. I will start with the background and concerns about the so-called SOE problems and related policy responses from the perspective of international investment law. And then I will talk about the SOE rules in the CAI compared with other international regulations of SOEs, including the Cptpp. And lastly, I'd like to share some preliminary thoughts about the future of international regulations of state-owned enterprises. Okay, next slide, please. I think Wei Huang has provided excellent overview of the challenges posed by Chinese SOEs and some policy responses to address them. But I want to add a few points from the perspective of investment law. First, with the internationalization of state-owned enterprises and rise of emerging economies like China, state-owned enterprises has become a significant global investor competing with private investor in home market and global marketplace. As far as investment regime has concerned, the involvement of states in cross-border investment by state-owned enterprises blurs the line between public and private, and has generated real and challenging questions about the status of SOEs as global investor and treatment to foreign SOEs within international investment regime. This is a unique challenge for international investment regime, and I'm actually working on a book project addressing the relevant issues. The SOE disciplines or SOE rules, however, we're talking about today are different issues. The SOE disciplines and SOE rules focuses on establishing obligations for SOEs engaging in commercial activities, and the major developed economies like the EU and the US have called for developing national and international regulations of SOEs to address their concerns over anti-competitive behaviors and subsidies by states and ensure a level playing field for their investors. Since the international investment law regime traditionally focuses on investment protection, SOE disciplines and obligations for SOEs are new frontier in international investment rulemaking. Against this background, the CAI between the EU and China, the first agreement to deliver detailed obligations for the behavior of states between the two major economies, is a breakthrough on SOE disciplines in specific, as well as international investment policy making in general. On the one hand, developing a new generation of modern, high standard and comprehensive agreements on investment with China has been a top priority for the EU for many years to address their concerns over the imbalance and level playing field in trade and investment with China. But on the other side, the CAI signals a significant shift in China's attitude to international regulations of SOEs, because because this is for the first time that China commits to discipline SOEs and fair competition in an international investment agreement. While the future of the CAI is uncertain at this stage, the agreement in principle of itself constitutes a development of investment regime and may provide a useful template for regulating SOEs in international investment treaties. And next slide, please. In terms of the specific CAI rules on regulating the behaviors of SOEs, there are some innovations in drafting. Here I would like to highlight a few salient features. First, unlike the Cptpp and other FTAs that provide a standalone chapter on SOEs, the CAI rules on SOEs are primarily found in Article 3bis under Section 2 of the Agreement for the Liberalization of Investment. Such a practice is in line with the EU's operational objectives in negotiating comprehensive investment agreements with China, of enhancing market access and also leveling the playing field for EU investors in China, especially before establishment. Furthermore, the CAI rules on SOEs must be read in conjunction with Article 3 on performance requirements, including prohibitions on technology transfer or license, which should apply to both establishment and operations of foreign investments. In that sense, the CAI touches upon the challenging issues of equality of competitive conditions and investment protection, not only between domestic and foreign investors, but also between SOEs and private investors. Secondly, unlike the Cptpp and other FTAs, the CAI does not use the term SOEs or state enterprises. Instead, it refers to a concept of covered entities. This term perhaps chosen carefully by both sides to avoid controversies surrounding the definition of state-owned enterprises. But as you can see in this slides, the covered entities goes beyond the majority ownership and traditional control tests contained in FTAs like the Cptpp and also the USMCA, and explicitly includes enterprises controlled by the states through minority ownership or legal title and de facto influence. So in other words, the CI rules will capture a broader definition, broader defined category of enterprises directly or indirectly owned or controlled by the states. And under the CI rules, state designated monopolies or entities with special rights or privileges are also subject to international obligations. So the CI does not only provide a broad definition of covered entities in line with the due consideration of ownership and control in defining SOEs in existing FTAs, but also include interesting innovations to address the anti-competitive concerns over other public or private entities designated or authorized by governments with privileges or monopolistic positions in a relevant market. Next slide, please. In terms of the substantive obligations, the CI requires covered entities to act in accordance with commercial consideration and provide non-discriminatory treatment in their purchase or sales of goods and services. In regard to the non-discrimination obligation, the CI explicitly requires the comparators that are used to assess the treatment accorded by covered entities in purchase of goods or services are in like services or like goods supplied by their home parties, investors, and entities, or subject to the in like situations in sales of goods or services. The requirement of acting in accordance with commercial consideration applies covered entities engaging in commercial activities, excluding situations of trade in goods and to supply services, unless through establishment of enterprise and operation of a covered investment. Unlike the commercial consideration defined in the Cptpp and other US-led FTAs, the CAI does not limit the other factors taken into account in commercial decisions to those of privately owned enterprises in the relevant business or industry. Instead, the CAI focuses on factors that would normally be taken into account in commercial decisions of enterprises, regardless of publicly or privately owned. This is perhaps a very important innovation or key features of CAI rules on SOEs, as it focuses on the behaviors rather than the identity of a covered entity. Next slide, please. Unlike Cptpp and other FTAs, the CAI also include transparency rules on SOEs. But the rules under the CAI is much narrower and softer in the forms of a best endeavor clause and is applicable to situations where the parties' interests are being adversely affected, though the list of information appears comprehensive. The CAI transparency rules has been criticized as less ambitious compared with the Cptpp and USMCA. The provisions is perhaps another compromise of the two sides, but the rule of transparency under SOE disciplines is a still, helpful attempt to address market distorting behaviors of SOEs in line with international good practice of corporate governance and transparency. And beyond the rules on SOEs, the CAI also contained a separate set of rules on transparency under Section 3, including transparency obligations as regards subsidies. This may arguably fill some gaps in WTO rules, and it also the CAI also provides a specific consultation procedures if a party considers that any subsidies could have a negative effect on its investment interests under the agreement. Next slide, please. The CAI does not only provide obligations for covered entities on non-discriminatory treatment and transparency, but also explicitly impose those obligations on regulatory authorities. Accordingly, the regulatory authorities of China and the EU shall act impartially in like circumstances to all enterprises, whether public or private, foreign or domestic, in a consistent and non-discriminatory measures with regard to enforcement of law and regulations, and independently from the enterprises regulated by themselves. These provisions further develop SOE rules in international investment agreements. Although like other disciplines on SOEs, the efficacy will depend much on the implementation in practice. Such treaty practice is consistent with the recent developments of Chinese law on foreign investment, and also reflects China's effort and commitment to implement regulations of SOEs and address concerns over fair competition among all enterprises and implementations by the local governments. Next slide, please. Last but not least, despite the broad coverage of covered entities and detailed rules on substantive obligations, the CASOE rules are also subject to extensive carve-outs and exceptions, as illustrated in these slides. To be clear, I agree with some commentators that too extensive exceptions may complicate the scope and application of SOE rules and undermine the stringency of obligations for SOEs. But at the same time, such exceptions are legitimate and necessary for both the EU and China, in particular to maintain sufficient policy space with respect to exercise public functions of state-owned enterprises. And this is not surprising because each party has considerable number of SOEs, and there are different political concerns and economic interests to address or take into account in negotiating international agreements on investment and to balance the investment protection with SOE rules. So to sum up, I think the CEI provides an incremental and balanced approach to regulate SOEs with some innovations. It develops the SOE rules on the basis of EU recent treaty practice, while China for the first time commits to international SOE disciplines in a bilateral investment treaty. While some argue that the CEI falls short of the high expectation, the future of the agreement in principle remains uncertain at this stage. The text of the CEI as it stands and the CEI approach to regulating SOEs unfold the efforts of the two major economies and important stakeholders to develop rules on SOEs. Next slide, please. So this brings me to the third part of my presentation. What is the future of international regulations of SOEs? Some commentators have advocated the use of Cptpp as a model for regulating SOEs or for shaping the international disciplines on SOEs. But I think we should not overlook the contribution and implication of the CEI approach to regulating SOEs in international investment treaty. As mentioned earlier, compared to the Cptpp approach, the CEI rules have a much broader coverage of enterprises for obligations, non-discrimination, commercial considerations, and transparency. And the CEI approach focuses more on the behaviors and conducts of covered entities rather than the difference between publicly and privately owned enterprises presented in Cptpp and other US-led FTAs. So in that sense, the CEI approach appears more neutral and favorable for the effective non-discrimination. Furthermore, the CEI approach to regulating SOEs appears to be incremental and balanced in line with the domestic reforms and the need for leaving sufficient policy space for exercising government functions and engaging in non-commercial activities. apart from the specific rules, I think it's also necessary to reflect on China's role in developing appropriate international regulations of SOEs. While China formally applied to join the Cptpp in September, there's still a long way to go for both China and the Cptpp members. By contrast, the CAI will constitute a milestone where China explicitly commits to disciplining SOEs and fair competition in international agreements. And the investment agreements can be considered as a joint policy response of China and the US and the EU to rising concerns over SOEs. And will likely have far-reaching implications, not only in terms of the disciplines on SOEs, but also other provisions on investment, liberalization, and dispute resolution, especially considering the two significant stakeholders' active involvement in the ongoing discussions on the future of international trade and investment law at the multilateral level. Of course, challenges remain for the future. On the one hand, the CI is subject to further modification and the prospect is uncertain. And on the other hand, some key issues for international investment agreements, like the investment protection and the related SDS, are unregulated in the current text. In addition, the interactions and also the interdependence between trade and investment law are increasing, but their impacts on reforms of international economic law remains to be seen. In this regard, the CA as a new treaty further contributes to blurring the lines between trade and investment law and expands to new issues. But in any event, the CAI provides a different model or template for regulating of SOEs that will contribute to the appropriate disciplines in the global economic governance. All right, I think I shall stop here. Thank you very much for your time.
Thank you very much, Lu, for the great insights of the SOE from the investment protection perspective, especially the approach taken under the EU-China Comprehensive Agreement on Investment, which seemed to take a different approach from the Cptpp. And I think that certainly raises some questions, on the future of SOE regulations, and we might come back to them during the Q&As. And now we would like to move on to discussions on a different topic. So our next two speakers will talk about actually the digital developments of competition law from Australian and Chinese perspective. So I will first introduce our next speaker, Professor Deborah Haley, who is a professor at UNSW Law and a co-director of CBEL. She is also a member of the Center for Law, Markets and Regulation. Her research and teaching focus on competition law and policy in Australia, China, Hong Kong, and the Asian nations, and she has also written very widely on them over a long period of time. She is a regular visitor to those jurisdictions who research and teach. Within the area of competition law, she is particularly interested in the role of government in the market, both in Australia and internationally, merger regulation, competition in banking and finance, and the digital economy. Deborah has taken a substantial research in the development of anti-monopoly law of China against the background of its political economy and has written widely along and with Chinese co-authors and in material also translated into Chinese. She has also consulted with and completed research project for UNTAD, OECD, and ASEAN. And she's a non-governmental advisor to the International Competition Network and a member of the Law Council of Australian Competition Law Committee. So Deb will talk about competition law recent digital developments in Australia. And Deb, the floor is yours.
Well, thank you very much, Kun. Thanks for the opportunity to present, and thanks to my fellow speakers. Professor Zhu says he spoke on a heated topic at the moment, CTPP and SOEs. I will now move on to a second very hot topic, digital. And digital and competition law are really buzzwords globally. If I spent 24 hours a day, 7 days a week reading books and articles on the topic, I wouldn't be able to keep up with what's being written or the various views, inquiries and reports which keep arriving on my desk. But at its most basic, the question is how we deal with the aggregation and growth of market power of digital platforms. Questions of how to deal with issues around data and privacy and how they might factor into competition are important in this discussion. Also, questions how to deal with barriers to entry created, tipping, lock-in, and killer acquisitions are at the forefront of the debate globally. And all jurisdictions are carefully considering their approaches, and this is the EU, the US, the UK, China. So I'm delighted to have the opportunity to address Australia's approach, which has been important globally. We've been an innovator in this respect. And of course, we have to keep in mind that in all of these considerations, we need to understand that the amazing benefits that digital platforms have brought to consumers and business. So next slide, please. So what I want to talk about briefly are a couple of inquiries that have been done in Australia, but by our Australian Competition and Consumer Commission, the ACCC, the Digital Platforms Inquiry, and the more recent Digital Services Inquiry. I want to talk about the ongoing work of the ACCC and also its ongoing merger reform work, which is influenced heavily by digital issues. Next slide, please. So I want to talk first about the Digital Platforms Inquiry. I have a lot of information on my slides, but I don't attempt to address it all. The first bullet point here is the formal title of the inquiry, but the second bullet point puts it into context. Really, it's all about Google and Facebook and their impact on advertisers, media content creators and consumers. And in relation to the platforms inquiry, there was a draft report in 2018 and a final report in June 2019, and I presented on this issue in a digital conference, Digital and Competition Law Conference in Shenzhen in December 2019. This was a political inquiry. It arose out of political manoeuvring, but ultimately it was very timely, and it was made more timely because of global developments, and it was made more effective because of the dual role of the ACCC as a competition and a consumer law regulator. Next slide, please. So I won't speak to all of the points on this slide, but I've provided you a useful summary, I hope, in the PowerPoints of the issues and the findings. What I want to talk about here is that matters to be taken into consideration included whether platform service providers were exercising market power in commercial dealings with creators of journalistic content and advertisers, and therefore the impact of all of that on the level of choice and quality in relation to news and journalistic content to consumers. So they are the key points that the inquiry was looking at, but of course a whole lot of other issues were considered. Next slide, please. So the key findings on market power, this was a generalised digital platforms inquiry, but to the ACCC's surprise, no one made any submissions about anyone other than Google and Facebook. So it turned into a consideration of Google and Facebook and their market power. And the ACCC talked about substantial degree of market power because that's our test in Australia for our dominance provision in competition law, our abusive dominance provision. We don't talk about dominance, we talk about whether the entity has a substantial degree of market power. And in relation to the inquiry as a whole, not surprisingly, the ACCC found that both Google and Facebook had a substantial degree of market power in markets for the supply of things like general search engines and search advertising services in Australia. And next slide, please. And the supply of social media services and display advertising services in Australia. And if you want to look back at those slides, you'll see the reasons why those findings were made. But both of them were clearly very influential in those markets and had a lot of market power. Next slide, please. So in the context of all of this, the ACCC made recommendations, very small recommendations on merger reform. And they were basically about acquisition of potential competitors, that so-called killer acquisition issue, when a major player, major digital platform acquires a small company. Are they actually acquiring it to use it in their business and expand and develop it to the benefit of consumers and possibly to benefit efficiency? Or are they going to use it to lessen competition by buying it and killing it off? And that's the killer acquisition point. And that's very difficult for a regulator to determine. So in the merger factors, which already exist in our merger provisions, in Australia we prohibit mergers if they have the purpose, effect or likely effect of substantially lessening competition. The Commission, there are factors that you need to consider in section 50 subsection 3 of our Act. And one of the new factors that the Commission recommended was the likelihood that an acquisition would result in the removal of a potential competitor, which doesn't really help all that much, but will turn the decision maker, in Australia currently the court, it will make them turn their attention to this issue when they are examining a potential merger. The second recommended merger factor to be included was the last bullet point, the nature and significance of assets, including data and technology, being acquired directly or through another body corporate. And these are issues which would focus the decision makers' attention on this. Now, there are issues with Australia's merger regime. It's very difficult for the regulator to prove in court the likely anti-competitive impact of a merger or the scenario going forward without the merger, and that's what our law requires the regulator to show or to prove to the courts. And even in a traditional market, that's very difficult, but it's a heightened problem where we have digital markets. So these new provisions were aimed at that, and there's a little more on that going forward. So the Commission, in its digital platforms inquiry, made 23 diverse law and policy recommendations, and I will leave these for you to look at. But they have set up a digital branch. They've looked at proactively monitoring and enforcing issues in digital markets. They've had an inquiry into ad tech services, and I'll talk a little bit about that. And they've developed a bargaining code for media platforms media and platforms involving bargaining principles where media bodies want to be paid for the work that is shown on digital platforms. So I won't talk about all of those. There are issues about privacy, about strengthening the Privacy Act, and that is going forward. Next slide, you could go through 2 slides, please. Another 2, yep. And another one. So all of the recommendations are set out there. So I want to move on now to talk to you about the Digital Advertising Services Inquiry final report, and that's in the next slide, please. of August 2021, and that's an inquiry into the impact of the large digital platforms in relation to ad tech. And ad tech services are those that are used in buying and selling digital display advertising, those pop-ups that come onto your screen when you're looking through Google as a search engine or using Facebook. And they are the automated use of complex algorithms and systems to trade these digital ads in a matter of milliseconds. And they allow a vast number of publishers to sell digital spaces on their websites to a vast number of advertisers. And of course, they play a critical role in their digital economy. They help Australian businesses to ensure that their advertisements are reaching consumers and reaching the right consumers. Next slide, please. And these are some of the issues which the Commission found in its overview of market power in this industry, but there's considerable anti-competitive self-preferencing by these digital platforms where they favour their own interests, and you might be aware of the cases overseas about this and the important Google shopping case in the EU, and there's an appeal coming down on that case from the highest court in the EU in the next week or so, and that was about abusive dominance in preferencing itself, preferencing its own shopping platforms on its shopping comparison site. Next slide. So if you have a look at these slides after the this session, you will see that the ACCC found that there was very weak competition in the ad tech supply chain, and it placed all the benefits to businesses and publishers and consumers at risk. So dominance was underpinned by the multiple factors such as the data advantage of the platform, their access to exclusive industry, inventory, and integration across all their services. And they, in all of this, they use data that they've obtained about consumers. So look, next slide is about recommendations. They recommended the ACCC be given power to develop sector-specific rules to apply in the ad tech market and address conflicts of interest, prevent anti-competitive self-preferencing behaviour, address data advantage issues and transparency problems where these create efficiency or competition concern, but they also cautioned that the rules needed to be proportionate, targeted at addressing the greatest harms and evidence-based, and they don't want to put an undue regulatory burden on the ad tech sector. But they also want them to be flexible and capable of adapting to the dynamic market and allow Australia to align its regulatory solutions to those adopted internationally. So the next slide is the formal regulations in full, and I won't go through those again. The next slide talks about the ongoing investigations of the ACCC, and the final slide talks about merger review. And what I would like to just talk briefly about is the proposals that the ACCC has put forward in a different context to review merger laws and completely overhaul them in Australia. The ACCC has trouble proving its claims in court. In fact, since 1993, it has not won a case under our current merger test. And that's pretty significant because all our cases are taken in court. The ACCC does not make administrative decisions. So if the ACCC wants to stop a merger, it has to go to court. So at the moment, given the nature of our substantial lessening of competition test, or likely substantially lessening of competition test, and the future with and without test that is used, it's incredibly difficult to show prospectively what is likely to happen to the requisite burden of proof in Australia. And of course, dynamic digital markets make that all worse, make it much harder for the ACCC. So the ACCC wants to change the wording based on traditional markets, but also in particular for digital markets. I won't talk about all of this, but there are proposals to move give the ACCC an administrative decision-making function and have it then appealed to the Competition Tribunal at first instance, because the belief is that better economic evidence will be able to be presented there and will be more likely to be accepted, because the tribunal has a judge, an economic expert, and an economist and a business expert. And as has been written, judges alone are much more comfortable with provable facts rather than supposition. And of course, all economic evidence is supposition. So that's why economists have a tough time in Australian competition law. But the last thing I want to talk about in relation to this is they will update the merger factors to focus more on digital. They will define likely with a lower standard of proof to redress that issue about future conduct. But basically, they want to put a deeming provision in the Act for acquisitions by larger firms with substantial market power that entrench, materially increase or materially extend positions of substantial lessening of competition. So that's basically a reversal of onus. And will be interesting to see how that plays out in future. So basically that's a tailored test mainly for digital platforms. So look, that was a real whistle-stop tour of what Australia's been doing and is doing in relation to digital platforms. What I would say is we have been a market leader in this. Our first report predated many of the others that have subsequently came along and has been quoted regularly. And as a sign of that, the chair of our Australian Competition and Consumer Commission has recently been appointed as the vice chair of the International Competition Network, and he'll be focusing on digital issues. So I will leave you with that, but obviously there's a lot to think about there, and I hope that you have learned something and have enjoyed the presentation. Thank you very much.
Thank you so much, Deb, for the very insightful presentation and great detail about the interesting recent development of regulation in Australia with respect to digital platform and edtech, and this particularly the ACCC's initiatives. That's very interesting. I have certainly learned something from your presentation. I'm sure the audience will have more questions to follow up, so we will probably come back to you later. So now we have a few minutes for Q&As. So we'll probably follow up with some speakers, the presentation based on the questions from the audience. So now on the SOEs, we have a question for Wei Huan from the audience. So do you think China will be able to comply with the Cptpp SOE chapter, even with similar exceptions taken by other Cptpp countries? Is there any pain point of the Cptpp on China? Wei Huan, do you want to respond to this question?
Thanks, Quinn, and thanks for the question. And it's a great question. And it's actually a very practical question for China to think about. What actions need to be taken to comply with the Cptpp's rules? I think the starting point, as I did in my presentation, is to compare the Cptpp requirements and the WTO requirements. The important thing to note, as I said, is that the Cptpp does not really extend significantly beyond the existing WTO rules. So in general, I think if China can comply with WTO rules, particularly China's WTO plus obligations, then China would be able to comply with the Cptpp's requirements on SOEs. But yes, there are some pain points. I think the first pain point is that China is at the moment outsider and some of the Cptpp members are closely monitoring whether China is able to comply with the Cptpp's rules. So that means that China needs to perhaps do something to show that China is winning and is capable of complying with the Cptpp requirements, including the SOE rules. So, I mean, the definition of the Cptpp rules, as I said, provides some flexibility. But again, it depends on how much China wants to comply with and how much that the members would actually require from China. The substantive obligations, I don't think it's an issue. It's quite similar to the WTO requirements. If it's going to be an issue, it's going to be an issue of enforcement in the future. Subsidies, the only extension under Cptpp is on services. So China needs to be thinking about, you know, the subsidies that provided to services providers as well. For example, the charging stations for the new electric cars, right? There are quite substantive subsidies there. So those are the subsidies provided to services providers instead of the goods. Transparency is a big issue and a big challenge for China. Now, again, depend on the negotiation or what the compromise might be, right? Some of the existing Cptpp members have exceptions. So whether China could actually get these exceptions, or would China be required to show willingness to comply with the very detailed notification rules and transparency requirements, for example, provides all information, most of the major information about all SOEs on its website. That would be quite a challenge. Again, finally, I think, again, it's about, you know, before China's accession, how much China would need to do to show its willingness and capability to comply with the Cptpp rules. So there will be some challenges, and after China entered, after the negotiation started, then it will be the question of compromise and how much exception China could actually obtain from the Cptpp members. Thanks.
Thanks, Wei Huan. Perhaps now we could also follow up on the presentation about regulation of digital platforms that we heard from Australian and China's perspective. I wonder our speaker could follow up on the international trend. So perhaps we have a follow-up question for Deb. So how do you think the proposals for the amendment, you know, to this Competition and Consumer Act and the recommendation in the two review that you mentioned compared to what is happening overseas? And is this of any relevance to China?
Debbie, you're muted.
Thank you very much. You would think I would have learned by now. Look, thank you very much for the question. And I think it's an interesting question because people all over the world are doing different things. And Australia has had the flexibility to approach the problem from a variety of standpoints, mainly because it has both the functions. It is a competition regulator and a consumer regulator, and it has also referred matters off to the Privacy Commissioner, etc. As to, I think I'm focusing on what we're trying to do. Around the world, everyone's looking at killer acquisitions, and I think the main option at the moment is, do we impose special regulations on the very largest digital platforms that don't apply to everyone else in relation to mergers? Do we make them give additional justification about why they are acquiring the target? And that's being looked at seriously in the UK. There's a discussion paper out that at the moment. All sorts of things are being looked at in the US. There are just too many to focus on. I don't think Australia is an outlier in anything it's doing, but in terms of things being done, China is actually at the forefront of it all. After having a relatively lax, one might say, or very permissive environment for digital platforms, wanting to encourage innovation, it came down very heavily on digital companies like Alibaba and Tencent last year, and it's now brought in, or it has brought in those new guidelines which Zhang Shenying was talking about, where they've divided them by size and are imposing different responsibilities on them and obligations under the law depending on how big they are or what their industry is. I think a lot of this is also bound up in China with the fact that the digital companies are so intertwined in the financial system, and I think that a lot of transactions were occurring outside the control of the central bank, etc., and I think they want to rein them in for that reason. So I think China is at the forefront of it all, although I think China has imposed obligations on some companies which possibly would not be acceptable in the West and so are unlikely to happen. But I think what China's doing is very interesting. So those are my answers to the question.
Thank you so much, Deb, for the insights. And we're about the time actually for us to close this panel. And I want to take this opportunity to thank all of our speakers for the excellent presentations and great insights. I've learned a lot from their insights, and for colleagues from Tsinghua for supporting the event, and for all the audience for attending and for the great questions. And also for our administrators, and particularly my colleagues at CBEL, Fion Chua and Wen Chen. They have worked very hard to support their event, and without them, this webinar would not have been possible. And so please also stay with us. We have another panel on the trend of digital currency and RegTech at 4 p.m. Later today. So we hope to see you again in some of the future CBEL events. And thanks again, everyone, for your participation.